welcome everybody. My name is Chris Sperry. I'm head attorney of the elder care firm. We have offices in Brighton, Livonia, Novi, as well as Bloomfield Hills. I want to welcome everyone to what we call a life care planning workshop, which is different than your typical estate planning workshop. Most people think of estate planning, they think of what happens when you pass away. Well, we're concerned with that, but also we're concerned with what happens if you don't pass away, continue to age, and face all the issues that go along with aging. And that's what life care planning is all about. So as we go ahead and get started, the agenda, we're going to review the handout material. From there, we're going to talk a little bit about my background, why I got into this. Then we're going to identify what made you decide to show up today besides the free water and cookies. Then we're going to discover the 3 steps to plan and protect your estate. And we're going to close and help you create an action plan. So if everyone could take out their folder, in here you're going to see an evaluation, okay, the blue evaluation. If you could take that out and fill out the top part. The top part is going to list your personal information. Included there is going to be a spot for email. If you do want to be included on our monthly newsletter, please make sure to include your email. If you don't want to be included, don't include your email. Below that, you're going to see an evaluation. Very important on a scale of 5 to 1, 5 being excellent, 1 being poor. I want you to give us, let us know how we did today. Because if you took time out of your morning to come listen to me talk about death, taxes, incapacity for an hour, hour and a half, I want to make sure you get good value. Now, if you circle all 1s, I'm going to assume you meant to say we were excellent. You screwed up, so if we were really that bad, I want you to write a legal term, write you suck next to it, so that we know that we were really that bad. Okay? So you can go ahead and circle 5s now if you want, or you can wait till the end. Okay? Then further behind that, you're going to see a couple other pieces of information. You're going to find a list of our upcoming workshops. You might be thinking, well, it's silly that you're giving me a list of your upcoming workshops when we're attending a workshop today. Well, we host these about once a week. And what we find is a lot of our clients, they attend one of these, and then they figure that I want my spouse, or I want a loved one, or a brother or sister to attend. So we include a list of our upcoming workshops. Then behind that, you're going to find a sheet where you can take notes. Behind that, you're going to find stapled together a lot of one-page, just frequently asked questions, things talking about asset protection trusts, Medicaid planning, what's a power of attorney, just one piece, one page, very easy to understand explanations. And then behind that, very important, you're going to find something called Take the Long-Term Care Challenge. And what this is a list of actual bills our clients are paying in certain care communities. And you're going to see it anywhere from $7,000 a month to, I think, just over $11,000 a month. And that can be pretty surprising. So it's important to figure out how are we going to plan for long-term care. Okay? And we'll talk about that in this workshop. And then on the other side, you're going to find a bookmark for a book I wrote in 2014 called Planning for a Loved One with Chronic Illness, where we talk about Medicaid planning, veterans benefits, a lot of things that we're talking about today. And then behind that, you're going to find a sheet talking about common estate planning mistakes, as well as common Medicaid planning mistakes. So there's a wealth of information in there, and that really calls back to my background. My dad was a professor for 43 years. We're big believers in education. I teach estate planning and elder law at Western Michigan Cooley Law School. So we're big on education, making educated decisions, know all the information out there, and then make a decision based on that. Okay? A lot of information there. So, now, with that evaluation, I'm going to make you 3 promises right now. Those 3 promises are: first, time's going to fly by. Second, you're going to learn something new. And third, we're going to have a little bit of fun, or as much fun as you can have when you're talking about death, taxes, and incapacity. So for those 3 promises, the one promise I ask from you in return is that you could just fill out that evaluation at the end. Sound fair? Okay, great. So, why I got into this is one of the few areas of law where you're just helping people, helping good families. I spent one summer at the Wayne County Prosecutor's Office, and that was more than enough for me. I wanted to do an area of law where I'm just helping good families because it's all about family. And this is my family. This is my son, Ryan. He's actually about to turn 6. And my daughter, Madison, she's 3.5 right now. But this picture was taken about 2 years ago when my son was 4, because he went through this phase where all he wanted to do was wear a suit and tie. Like no matter what. He was playing outside in the sandbox, and he'd be wearing like a bow tie or an outfit like this. And so we thought, well, we have to get a picture. And this picture is hilarious. It might be a little bit hard to see, but you see that he's wearing a vest. I've never worn a vest like that in my life. he's wearing a pocket square in his vest. I don't own any pocket squares. And he has a pocket square in his jacket as well. He's doubling up on the pocket squares. Versus his dad, who hates wearing a suit and tie. In fact, I'm going to loosen up my tie a little bit. And then this is my daughter, Madison. As you can see, she's all attitude. But it's really about family, and I've had to go through some long-term care issues with my parents, where in fact I live 4 houses down from my parents, because I'm an only child and I help them with certain things. There's a period of time where neither of them could drive. And it's all about family and trying to protect your family. So that's a little bit about my background, why I do this. Also in your packet, you're going to see a sheet that talks about our team. So in addition to myself, we also have another attorney, Brandon Thompson. And then we have a support team of about 8 other individuals. So it's not just me, there's a whole team at the elder care firm supporting you. And we're big supporters of the Alzheimer's Association. There's a big walk in Brighton, October 1st. We're a major sponsor there, as well as volunteering to help out. And we're on the board organizing that walk, as well as the Area Agency on Aging. And now the last thing about me, before I'm going to ask you what made you decide to show up here today, is this concept of life care planning, which is pretty unique. So think of it kind of like a bridge. At the beginning of the bridge, you have your typical financial planner talking to you about retirement or IRA rollovers, that type of thing. And then at the end of the bridge, you have your typical estate planning attorney who's only talking to you about what happens when you pass away. Where does your stuff go? But no one's doing a very good job talking about the whole process and what happens in between. And that's really what elder law and life care planning is about. Not just planning for what happens if you pass away, but what happens if you don't continue to age and face all the issues that go along with aging. And that's what we call life care planning, is just taking all of this into account, not just this piece or this piece, but the whole bridge, the whole journey. Okay? Now what this is a lot of questions people who've sat in your seat have asked. What is a power of attorney? What's a living will? Medical power of attorney, what's a trust, how do I avoid probate, how do I protect my stuff? Now what I would love to hear is what made you decide to show up here today, besides the free water and cookies? Anyone willing to volunteer?
Yeah, I want to make sure that I know what I'm getting into, my mother and myself.
Sure, yeah.
She's been in assisted living now since last August. Mm-hmm. And it makes me think about, I don't have a will, I don't have anything,
right.
You know?
Yeah, yeah. So if I can echo that, the concern is kind of planning for mom. Mom's in assisted living, dealing with that. But then now that I'm thinking about mom, now I want to refocus on myself and make sure my own ducks are in a row. Mm-hmm. And I think that did a great job of hitting the nail on the head of generally people come to these workshops for 1 or 2 reasons. The first reason might be planning for mom or dad or planning for a loved one. And then the second reason is after going through that process or dealing with that crisis, making sure that my own ducks in a row and I'm not going to leave a mess to my kids or anyone else to clean up. So I appreciate that. And for being the first person to answer a question, what I want to do is give you a copy of the book.
Thank you.
Yep. So that book is published in 2014, and when you get a book published, one of the cool things is you get checks quarterly, like royalties for all the sales. And I promised that all the book sales would go to help pay my kids' college education. So after 3 months, I got my first royalty check for $150. So I'm well on my way to paying my kids' college education, one book at a time. But anyone else willing to volunteer? What made them decide to show up here today? Sure. Yeah.
I'm interested in learning about VA benefits
Sure.
and eligibility for my mom.
Okay.
I believe she's a viable candidate, but there are some loopholes. It's more involved than I
Sure.
just at a quick glance think she's eligible.
Right.
It's more involved.
Yeah. Yeah. So our comment is it's planned for VA benefits for mom, who's probably a surviving spouse of a veteran. So we're going to spend some time talking about that and talk about some of the pitfalls and the qualifications and process for getting someone qualified, because you're going to hear a lot of different things. In fact, you'll hear a lot of different things even from the VA themselves. And as a VA accredited attorney, it's my job to remove the roadblocks between veterans and their benefits. Okay, and we'll spend some time talking about that. So I appreciate that. And as we're going through these workshops, or this workshop, we like to keep it relatively small and intimate so that if you do have any questions, go ahead, raise your hand and ask those questions. Now understand we don't have any attorney-client privilege today, but I do want to make sure that you get your questions answered, because today is going to be the cheapest time you ever spend with an attorney, so I want to make sure you get your money's worth, okay? So with that, we'll go ahead and get started. So the goals of the workshop: first, we want to identify if your current plan meets your goals. And now as we're talking about this, again, we might be talking about it for you personally, or we might be talking about it for mom or dad. Figure out if their current plan meets their goals, okay? Understand what it takes to protect you and your stuff, and show you how to get what's missing. Really figure out if we're all set. Do we have our ducks in a row? So we break it into 3 steps. 3 steps. And the first step is to know the rules.
Is that Al Pacino?
The question is that Al Pacino? No, that's a stock photo that kind of looks like him. Yeah. So the first job is to know the rules. Thanks, welcome. Here you go. So the first step is to know the rules. From there, we need to know the threats, know the predators, and then third, know the options. So we're going to start with understanding the rules. Understand that the government has a set of rules for you. They have a set of rules for you while you're alive, and then a set of rules for you if you were to pass away. And first, we need to know the rules while we're alive. So think of it as we can rely on the government's rule book, or we can set up our own set of rules, our own rule book. So during our lifetime, there's a set of rules, and people are surprised by this idea of living probate, okay? So understand that if you were to get a knock on your head, the court is going to take control over your affairs unless you've appointed someone to make those decisions, with maybe a financial power of attorney or a medical power of attorney. Now, if you don't have these things, then what's going to happen is you're going to have to go through a guardianship or conservatorship process, where the court appoints another person. It could be a family member, it could be an attorney, who now will manage your affairs for you. But the important thing is to understand that they have to answer to the court. The court is really the person making the decisions. And it's a guardianship if we're making decisions with regards to your care, and it would be a conservatorship if we're making decisions with regards to your money. Most people don't want to leave it to the court, but instead they want to take control. They want to create their own rule book. And the way we do this is by utilizing certain tools. The first tool is what's called a financial power of attorney. That's the document that appoints someone to make financial decisions for you if you're unable to. Okay? Question?
Is that a business power of attorney?
So the question is that a business power of attorney? I'm not sure what you're referring to with a business power of attorney. Or could you give me an example?
If I think it's a financial
Okay.
thing, and I think some people call it a business power of attorney because it's either business or medical.
Yeah, so the comment is some people differentiate between a business and a medical power of attorney. So in that sense, yes, it's to manage your finances, to pay your bills, that type of thing. So that's what I'm talking about with that financial power of attorney. Sometimes you might hear called a durable power of attorney or general power of attorney. All of those are referencing what we call a financial power of attorney, a power of attorney to make financial decisions if you're unable to.
If you're the power of attorney, is there one power of attorney that can cover both? I think that's what I think I'm the power of attorney for my dad.
Right.
And I believe I have the opportunity, I mean, I know his desires.
Right.
But I can do both.
So the question is there one power of attorney that could handle both? And the answer is an answer that we actually learned in our first year of law school. Whenever someone asks us a question to make us sound smart as attorneys, we answer it depends. So the answer is it depends. That said, typically we will have separate powers of attorney because they're very different powers. And we don't necessarily want to share all of our financial information with doctors and hospitals. So we'll have a separate medical power of attorney as well as a financial power of attorney.
I have one additional question.
Sure.
Did the power of attorney transfer, his attorney was in a different state, proclaiming me as the
Sure.
attorney. I'm assuming I contacted that attorney a couple of years ago. My dad's been living with me for 4 years.
Mm-hmm.
It seemed like everything was in place. Is that, I mean, is that
So if I can restate the question, can you have a power of attorney that was done out of state?
right?
The answer is yes, but that said, each state has different rules. So I would recommend that if Dad is a resident of this state, that we have a financial power of attorney done in this state, okay? Because especially medical powers of attorney. Medical powers of attorney are very state specific.
One last question
Sure.
before I'm
Yep.
interrupting here. If for the financial power of attorney and or medical power of attorney, would you, if you had children that are caring for the parents, would you list 2 people, or should you have 1 person?
Sure. Yeah, so the question is, should you list 2 people? Should you have 1 followed by a successor? And the answer is, it depends. It depends on what the family's goals are, but you can do it anyway, okay? And we're going to get to that point of there's no perfect tool or perfect answer, because it all depends on what the family dynamics are and what are your goals. And based on what your goals are, then we can advise you on what your tools are. So it might be a little bit frustrating, but for a lot of these answers, it depends. It depends on what you're exactly trying to do. But what I want you to understand at this point is there's 2 important documents here, the financial power of attorney and the medical power of attorney. And included in that medical power of attorney is going to be what we call living will type language. So Michigan is the only state that doesn't have a statute on what a living will is, which is end-of-life decision-making. So who here's heard of Terri Schiavo? Right? Yeah. So she was a woman in Florida who was in a vegetative state. Her husband wanted to remove her from life support. Her family wanted her to remain on life support, and it became a big court battle that lasted over 8 years. That easily could have been avoided by having a medical power of attorney, appointing her husband as what's called patient advocate in Michigan, the patient advocate for her, and included in that document would be the ability to remove her from life support, which is very important. And there's a couple things I want you to take away from that Terri Schiavo situation. First of all, just because she was married, that didn't automatically give her husband the ability to remove her from life support. We need to have this in writing. Okay? So also think about maybe if you have adult-age children, 18 to 25, just because you're a parent, you don't have the ability to make healthcare decisions or financial decisions. So if you have a college-age kid over at Grand Valley in Grand Rapids and they become incapacitated, even though you're paying their health insurance, you don't have the ability to get access to medical information or necessarily make those decisions for them. So anyone over the age 18 should have a financial power of attorney as well as a medical power of attorney. Yeah, question?
Now, does that change once a person passes away? Because isn't it typically when someone passes away, the husband or the wife is in charge of?
Sure, yeah. So the question is, does that change when someone passes away? Well, what happens when someone passes away is that the financial power of attorney and the medical power of attorney cease to be effective anymore. Then we're getting into issues of probate and joint ownership, which we'll talk about next, actually. So that's the government's rule book while you're alive. The way that you avoid the government's rule book while you're alive is by having that financial power of attorney and that medical power of attorney, 2 very important tools. Now, the government has a set of rules for us when we pass away. And again, it's a choice. Do we want to rely on the government's rule book, or do we want to create our own set of rules? And so when someone passes away, there's 4 ways assets get out of your name, or get out of their name. First is through joint ownership. So you have husband and wife, husband passes away, they have a joint checking account or a house that goes to the survivor. Second, we have beneficiary designations. You have an IRA or 401k, you pass away, it goes to, or life insurance, it goes to whoever you've named as a beneficiary. Third, we have trusts, and we have revocable trusts, and we have asset protection trusts. And we'll talk about the different types of trusts shortly. But if an asset doesn't pass through joint ownership, beneficiary designation, trust, it ends up going into probate. And most people want to try to avoid probate. Probate is a court process, it's costly, it's time consuming. By statute, a probate in Michigan takes at least 5 months. Typically it takes over a year. And it's public. Anyone can get access to whatever is going through probate. So who here has heard of Prince, right? Prince didn't have a will or a trust, and now all of his information is going through probate in courts, and anyone can get access to those records. So most people want to try to avoid probate. So what did I not mention? I didn't mention a will. A lot of people think a will avoids probate. However, it doesn't. What a will does is gives instructions to the probate court on how to administer your estate. So if you want to try to avoid probate, then maybe having a will-based estate plan where you're relying on that will to direct where your assets go probably isn't the best way to do it. You might look at a trust, or you could possibly do it through beneficiary designations. Okay? So that's the government's rule book when you pass away. How do we avoid that? Typically with the trust. So we've talked about some tools so far. We've talked about a financial power of attorney. We talked about a medical power of attorney. We talked about a will, a trust. Understand those are just tools. Okay? But what we actually need to do is we need to come up with a plan, okay? Because if you ask me, do I need a will, do I need a trust? It kind of depends. For example, if I ask you for a paintbrush, would it matter whether I'm painting the walls or am I painting a little figurine? Because all of these documents are different. It's what we're actually planning for. And that's, and understand that not all documents are created equal. Okay, just because you have a financial power of attorney, what's more important is what does that financial power of attorney actually say, or what does that trust say? And I'm going to pick on the financial power of attorney document because probably that's the most important document when we're planning for a loved one who needs long-term care, because that gives us the flexibility to plan for veterans benefits or Medicaid planning, or move their assets around, make sure they avoid probate when they pass away. And what I find is a lot of the financial powers of attorney that we review are lacking, because first of all, they might be what I call a blank check. So if you have one of these 1- or 3-page financial power of attorney that are very general, we call that a blank check. Because if you try to go and use that at a bank, what's going to happen is the bank is going to be in cover my butt mode, and unless they see it specifically listed out what you need to do, they're going to say, no, I don't see that you have that ability to do that. So our financial power of attorney in our office is about 20 pages. And it's not because we like killing trees or we're paid by the word. It's because we found that we need to include all of this very specific language in that financial power of attorney document. And then the other big issue that I run into with the powers of attorney is that they don't include what I call expanded powers. In fact, a lot of times they put limitations on what you can do as a financial power of attorney in terms of moving money around, creating asset protection trusts, making gifts to help protect or qualify for governmental benefits. A lot of powers of attorney don't allow you to do that, so they actually put handcuffs on you. Versus our financial power of attorney, we include these expanded powers to give the person we're appointing more flexibility to do whatever they need to do. Was there a question?
I did have one. So, but if you were in the joint, you got one bank account, and you don't have a lot of money, and you're the joint owner
Yep.
of that bank account,
Right.
then there's no need for a financial power of
Yeah.
attorney.
So,
And if you have a good family dynamics
Yeah.
where you're all in agreement.
right. So the comment is, if you're joint owners on a bank account, do you need a financial power of attorney? And the answer is,
It depends.
it depends. But that said, I'm not a fan of joint ownership at all, because there's always a better way to do things. Because there's issues with joint ownership. You mentioned there's good family dynamic. Well, what if something happens in that family? Mom's named daughter on a bank account. Daughter can at any time clear mom out of all of her money. Or what happens if daughter gets in a car accident and is sued? Mom could lose the house if they're joint owners on the house. Mom could lose that bank account if they're joint owners on that account. Or if you go through a divorce. Well, guess what? Anything you're titled jointly on is countable in that divorce. I've even had in my office a situation where daughter was named jointly with mom on a bank account, and now daughter actually needed long-term care in a nursing home, was trying to get qualified for Medicaid, but because she was named jointly with mom on an account, it was a countable asset. So I'm not a big fan of joint ownership. There's almost always a better way to handle things, whether it's through beneficiary designations like a transfer on death, or having that financial power of attorney document. And then also with that financial power of attorney document, what it does is creates a fiduciary relationship or responsibility, a fiduciary responsibility, where you need to act on behalf in best interest of mom or dad or whoever you appointed, versus joint ownership. There's no fiduciary responsibility at all. So I'm much more a fan of powers of attorney, maybe transfer on death to avoid probate, instead of joint ownership. Joint ownership should only be with husband and wife. Is there another question?
Okay, I am power of attorney for
Yep.
my mother. I'm also joint on her bank account.
Sure.
I don't need to be joint?
So the question is, I'm power of attorney. Yeah, so a couple people. So the question is, I'm power of attorney for mom, and also I'm joint ownership on that bank account. I would recommend that you remove yourself from that joint ownership, because what happens if you get in a car accident, sued,
Right.
something happens, mom could lose that money. Because that power of attorney, if it's a well-drafted power of attorney, it'll allow you to do whatever you need to do.
Okay,
Yeah.
so I should probably go to the credit union and show them that and see if that's-
Probably, right. Yep,
Yeah, 'cause
yeah.
I don't want to use all
Yeah.
the money she has.
Yep. So we talked about powers of attorney, and it's one thing to have a document that appoints you to make decisions, but we think it's important to include another tool, another document. We call it a personal care plan. So it's one thing to have someone tell someone to make financial decisions, it's one thing to tell them to make medical decisions, but it's another thing to give them instructions on how to care for you, how to use your money, what type of care do you want? Do you want to be kept at home as long as possible? Certain television shows you want to watch, certain hobbies you want to try to engage in. Certain foods that you want. For example, in my personal care plan, well, growing up, my parents gave me 3 foods that I didn't have to eat. I didn't have to eat tomatoes, tuna fish, and onions. I came around on the onions and tuna fish. I had some tuna salad, in fact, this week, but I still hate tomatoes. I can't stand tomatoes. I like salsa, I like chili, I just don't like the consistency of tomatoes. And my son thinks it's hilarious to try to sneak tomatoes into my salad when I'm not looking. I'm like, Ryan, I see it. And he's just sitting there giggling.
I see it.
Yeah. But I had a client I was working with a little while ago, and we were working on his personal care plan. And he said he didn't want lima beans. I'm like, okay. Didn't want tomatoes. I was like, ah, my brother. But then he wanted hard cider and Crown Royal once a week. And I was like, this is the guy I want to party with in the assisted living. So it might sound a little bit silly, this personal care plan idea, but understand that if you become incapacitated, it doesn't just affect your mind, it might be your body, and you still are who you are. So we think it's important that you put together this personal care plan to give instructions to people who are going to care for you on how you want to be cared for. And so we help our clients with that process. So we think adding to that financial power of attorney and medical power of attorney, it's important to have that personal care plan as well. And again, this is what differentiates what we do as life care planning, to show that we're not just planning for what happens when you die, but planning for what happens if you don't, and you continue to age and you face all the issues that go along with that. So those are the rules during your lifetime and when you pass away. And you can rely on the government's rule book, or you can create your own rule book. Now we're going to talk about the threats and the predators out there. So government, long-term care costs, market risk lawsuits, and your family. And some of these are going to be surprising, others might not be so surprising. So the first threat, the first predator out there we have is the government. Obviously not a surprise. Most people want to protect themselves or their loved ones from the government. And we talked about the guardianship, so the rule book during your life, how the government can get involved in your life while you're alive. And then we talked about probate, what happens when you pass away and how we probably want to avoid probate. Now we're going to talk about taxes. And we're going to talk about taxes as it relates to three different areas. We're going to talk about income tax, gift taxes, and estate tax. And we're going to start with estate tax. Most people have heard of the death tax or the inheritance tax or the estate tax. The way it works is the government has given you a coupon or exemption amount, meaning as long as when you pass away you have less than whatever that exemption amount is, you owe zero estate taxes. In the past, that exemption amount was $600,000. So you add up all your life insurance, 401k, the value of the home. If you pass away with over $600,000, that could be taxed, okay, up to 45% at the time. Now, that exemption amount today is $5.43 million, meaning as long as you have less than $5.43 million, you don't owe any gift tax, or don't owe any estate tax, or death tax, or inheritance tax. So who here has won the Powerball recently? Yeah. Right? Not that big of an issue. Now, where it is an issue is if we have estate plans that include this estate tax planning language, because it makes administering those trusts more difficult than they need to be. Because in the past, a lot of people thought you only did a trust if you had an estate tax issue. Well, that's not the case. And we're going to talk about some other reasons why you might want to look at doing a trust. Okay? So that's the estate tax. Now we're going to talk about the gift tax. Okay? A lot of people have heard that I can give away $10,000 or $14,000 to as many people as I want with zero gift taxes owed. And that's correct. But one thing I want you to keep in mind is that when you give that money away, it's gift tax free, but it's not Medicaid look-back free. And we haven't spent any time talking about Medicaid, but just generally understand Medicaid can help pay nursing home costs, and we'll spend more time talking about it, but it has a 5-year look-back period, meaning it looks back 5 years. Yep. It's a 5-year look-back period. So it looks back 5 years to see if you've gifted or moved any money around. And if you have, they're going to penalize you. Now, there's no $10,000 or $14,000 minimum that you can give away. They don't care how much you give away. They're going to penalize you for all of it. Okay? So a lot of people think, oh, I can give $10,000 away. Well, that's great for gift tax purposes. It's not for Medicaid purposes. In fact, I had a client I worked with. We were planning for, I was working with the mom, planning for grandma. Grandma had given away $10,000 to a bunch of the grandkids for their college education. Then grandma had a stroke and had to go into a nursing home and wanted to qualify for Medicaid. So they looked back 5 years, and grandma had given away these gifts, and they were going to penalize her with the idea that whoever she gave that money to was going to give that money back. So do you think the grandkids had that money to give back? No. Yeah. So I'm not a big fan of gifting. I want you to stay in control, or I want your loved ones to stay in control. In fact, we have a saying in our office, screw the kids. Like, I want to make sure you have the best quality of life possible, and then we'll worry about passing things down to the next generation. And then let's talk about income tax. And we're going to talk about income tax as it relates to your IRAs. So who here has an IRA or 401k? Most everyone, right? So this is one of the areas we see the most missed opportunities in how we plan for those IRAs and protect those IRAs. Specifically when we're dealing with beneficiary designations. So there's a lot of confusion, even confusion among attorneys and financial planners with how do we pass these IRAs down to the next generation as efficiently as possible. And so you generally have two options. Option one is you can name your kids outright as a beneficiary. Option two, if you have a trust, is you can name your trust as a beneficiary of the IRA. Typically you'll name a spouse first, then it might be kids or it might be a trust. So who here has named their trust a beneficiary of the IRAs? Anyone? Okay. Who here has named kids beneficiary of the IRAs? Okay.
My sister.
All right. Yeah. Yep. So do you want to hear the right answer, how you're supposed to do it? The answer is?
It depends.
It depends. Yeah. But we'll walk through it to understand which choice makes more sense. So if you name your children outright as a beneficiary of an IRA, they have the opportunity to take it all at once, or they can stretch it out over their lifetime. Because you understand, once you turn 70 and a half, you have to start taking out RMDs, required minimum distributions, right? Then if you name a spouse as a beneficiary, you can do what's called a spousal rollover, where now the IRA becomes the surviving spouses. But then when you leave it to the next generation, it becomes what's called an inherited IRA. And what happens is that they need to start paying income tax on it. They can either take it all out at once and pay the income tax at once, or they can stretch it out over their lifetime. So if at 70 and a half you have a 4%, you have to take out 4% every year, but maybe it's a 40-year-old inheriting that IRA, they have to take out RMDs, but it might be at 2%. It might be at a lower rate, but they still have to take out the RMDs, right? So you're giving the children an option. But let's say it's your son, and your son makes poor financial decisions. So you pass away, spouse passes away, leaves it to the son. Let's say it's $300,000 IRA. Now he sees the opportunity to pay off all his credit card, his student loans, buys that car he wanted, buys a cottage up north. Blows through all $300,000 all in 1 year. Well, what happens at the end of the year? He has to pay the income tax on it. So you just put your kid in federal tax debt because he doesn't have the assets anymore to pay that income tax. Okay? But maybe we leave it to your daughter and she makes good financial decisions. She's married, she has 3 kids. She wants to stretch it out. She makes the right decision of trying to stretch it out over her lifetime so she doesn't have to pay all the income tax, jumping her out to the top tax bracket all at once. But what happens if she gets divorced, gets in a car accident, gets sued, goes bankrupt? Then that IRA is also lost, right? So you might be saying, well, I don't want to name my kids a beneficiary of the IRA. Instead, I'm going to name the trust the beneficiary of the IRA. And if the trust is set up properly, we can protect against poor financial decisions, or we can protect against that outside environment, the divorces, lawsuits, credit, or bankruptcy. But there's confusion about naming the trust as a beneficiary of the IRA. Prior to 2004, if you were to name a trust a beneficiary of the IRA, most likely what's going to happen is that all of the income tax has to be paid within 5 years. Okay? So you can only stretch it out up to 5 years versus stretching out over the kid's lifetime. But in 2004, one of my colleagues had what's called a private letter ruling, which is basically a tax case that said if you set up a trust in a very specific way, and he used what's called a standalone retirement plan trust, so a trust just for the retirement accounts, then you can have all the advantages of option 1, stretching it out over the lifetime, as well as all the advantages of option 2, naming the trust and building in that asset protection. So we started doing standalone retirement plan trusts. But now we can take that standalone retirement trust language and put it inside of our trusts, our typical trusts, so that we can have in your revocable trust the ability to name the IRA or the trust as a beneficiary of the IRA, so we can have the asset protection as well as that stretch out ability. Okay? So that's the IRAs, and I see a lot of people with a missed opportunity where they're just naming kids outright as a beneficiary. And I think a lot of times it might make more sense if the trust is set up properly to name the trust as a beneficiary of those IRAs. Now we're going to talk about long-term care costs. So this is not a surprising threat or a predator to your estate plan. And what we see is what we call the elder care journey, where we start out living at home independently, and then as we begin to age, we need more and more help. And that help might be from a spouse until we have caregiver burnout, might be from the kids, then we might need to bring in commercial home care. Commercial home care is going to run you $1,000 to $3,000 a month if you're buying a couple hours per day, a couple times per week. Round-the-clock home care is going to run you easily $15,000 or more. Then we might transition to independent or assisted living. Think of this as apartment or Hotel type environment, they'll do your laundry, make your meals. Sometimes after a long day, I wish I was in assisted living. They take care of everything for me. I can play shuffleboard. But it's an apartment or hotel type environment. And there might be services available there. But assisted living is going to run you somewhere between $2,000 to $5,000 per month. Then you might have to transition to assisted living with memory care. So it's that same apartment or hotel type environment, but more of a protective environment with services geared towards memory care or Alzheimer's or dementia. That's going to run you $5,000 to $7,000 a month. And then the final step is nursing home level care, skilled care in a nursing home. That's going to be more of a hospital type environment. That's going to run you anywhere from $7,000 to $12,000, $13,000 per month. So the issue, what's that?
Unless you're on Medicare?
Yeah, so the comment is unless you're on Medicare, and it's actually Medicaid. Yep, yeah. And we'll talk about Medicaid and Medicare and how we're going to pay for it. Because in reality, we have 6 ways to pay for long-term care, and that's it, only 6. First, we can private pay out of our own funds. Okay, so how much money do we have? Investments, 401ks, life insurance, home equity. Second, we can have the kids pay. A lot of times they don't pay financially, but they pay in terms of their time, whether they're visiting the elder law attorney, or they've put their life on hold to serve as a full-time caregiver. Okay, and we don't want to rely on that. Third, we can have Medicare. Okay, Medicare pays for short-term rehab. It's not going to pay for long-term care. So if you go into the hospital, admitted for 3 days, you get discharged, you can have 1 to 20 days with 0 out of pocket. 21 to 100, you're going to have a copay of about $160 per day, unless you have supplemental insurance to pick it up. And then after 100 days, Medicare is going to run out. Then you have to go 60 days before trying to trigger Medicare again. So that's Medicare. It's not a long-term care payer. It pays short-term rehab. Also, it helps pay for hospice as well. Okay? That's Medicare. Fourth, we have long-term care insurance. Now, long-term care insurance in the past had gotten a bad rap because we just had what's called pure long-term care insurance, where if you don't use it, you lose it. They hiked up all these premiums. Now we have different ways of using long-term care insurance, tying it sometimes to investments, where you can have maybe one part long-term, you invest a chunk of money and that buys you long-term care benefits as well as life insurance as well. So you know you're going to hit one or the other. So let's say you put $100,000 in, that might buy you a $150,000 death benefit or a $300,000 long-term care benefit that you can draw on. So long-term care insurance, it's not a magic wand, it's not a silver bullet or magic bullet, but what it is, it's a tool. And it's just a matter of using the right tools for the situation.
Now, the long-term care insurance, that's going to pay for your assisted living or your nursing home?
So the question is, would long-term care insurance pay for assisted living or nursing home care? It can, and it also could pay for home care as well, depending on how that long-term care insurance is set up. So it is an option. It's one of those things, though, that you need to plan for it ahead of time versus waiting to the last minute. And that's a big takeaway I want you to have, is the earlier we start thinking about these things, get our ducks in a row, the more options we're going to have in terms of planning. Yeah, question?
It's related to what you just said. So do you have to set up your own long-term care, or can you do it for a parent, per se?
Sure.
On their behalf?
Sure. So the question is, are you only allowed to set up your long-term care insurance, or can you do it on behalf of a parent? You can do it on behalf of a parent. A lot of times kids will pay for the long-term care insurance for mom or dad because they know that it's either going to be me taking care of them or I can buy this long-term care insurance for them. Yeah. Yep.
Do they have to be before they start failing?
So the question is, would that have to be before their health starts failing? Most likely, yes. Right. Yep. Yeah. So that's long-term care insurance. So we've talked about private pay, kids pay, long-term care insurance, Medicare. Fifth we have is the VA benefit. So the VA benefit is probably my favorite tool when it comes to planning for long-term care. We've been working with the VA benefit since 2008. I was one of the first VA accredited attorneys in Michigan. And the VA benefit is great because it can help pay for home care, can help pay for assisted living, can help pay for nursing home level care, and you can bring in up to a maximum this year of $2,120 a month tax-free to help pay for that care. Now there's 5 requirements for the VA benefit. First, the first 3, we look to the discharge papers, or DD-214, or separation papers. First requirement, 90 days active duty. Second requirement, 1 day during a period of conflict.
Oh, just 1 day?
Yep, just 1 day. Third requirement, cannot be dishonorably discharged. So what we do is we look to the discharge papers, separation papers, DD-214 for that information. That document is the most important document. We need to make sure we have one, or we've requested a certified copy of those discharge papers. Yep.
Question, if you have the discharge papers and if you have the, I have it with me somewhere, the separation of service, original documents that are 50-something years
Sure.
old or whatever.
Yep.
Do you need to get a certified copy if it doesn't say the DD-214,
DD-214?
if it doesn't say it on the document because it was prior to 1946
Right. Yep.
and it's a naval nest part, whatever, is
Right.
that acceptable, or do you have to spend money and time and?
Well, you can request a certified copy of those discharge papers online for free. There's no cost to that.
If I can't find my dad's.
Right, yep. Or you can also go to a veteran service organization. Each county has one, so Oakland County, Livingston County, where they can assist you in getting those, and there's no cost to that.
Through the VA for his
Right,
medical
yep,
needs, would
yeah.
they have it then?
They might, yep. So those discharge papers are very important. You can always request a certified copy. And sometimes families that do have the originals ask for a certified copy just because they don't want to send in the original.
That's what I'm asking.
Right, so-
What is the norm, and if you have the originals, does that suffice, or
Right.
technically do
Yeah.
you need a raised seal on it?
So the question is, will the original suffice? The answer is yes. You can do it either way. You can either send in the original, or you can also get a certified copy. Either way will work.
Free online.
And it's free online. You go to the Veteran VA website, and there's a place to request that. So 90 days active duty, 1 day during a period of conflict, cannot be dishonorably discharged. We look to the veteran, or if it's a surviving spouse of a veteran, we look to the deceased veteran's claim. Then the two other requirements, so the fourth requirement and fifth requirement, this is where it gets a little more confusing. Fourth, we have an income test, and the way it works is we look at the amount of long-term care costs going out versus the amount of income coming in from Social Security and pension. So the amount going out needs to meet or exceed the amount of income coming in. So let's take an example. So we have Dad, who's a veteran. He has $1,500 a month coming in from Social Security, $400 a month coming in for his pension, so a total of $1,900. He needs to be paying basically more than $1,900 in long-term care costs. So if he's paying a home care company $2,000 a month, then that's going to pass the income test. Or if we have a personal care contract, Dad could even be paying son or daughter, even if they're not a nurse or anything like that.
You know, my dad's lived with me for 4 years.
Right.
And I heard something. Would that be through the VA or through Medicare? He's 100% blind and uses a walker.
Right.
So, I mean, he does not, basically none of farms out.
Right, yeah.
He changes, whatever, but I get his food, I get his pills, I get all of his meals, I do his laundry, et cetera, et cetera.
Yep.
Take him to the appointments.
Right. So you were serving as a caregiver. Had we sat down and talked, we could have done a personal care contract where Dad pays you, say $2,000 a month, and now the VA will come in and reimburse Dad up to that maximum allowable pension rate. So it's great for paying for home care, even if it's a family caregiver. So that's the income test. So 90 days active duty, 1 day during a period of conflict, cannot be dishonorably discharged, more long-term care costs going out than income coming in. The fifth requirement is an asset test. Okay, so we look at assets. And for a single individual, if you have more than roughly $30,000, you're probably not going to qualify. If you're a married couple with more than $60,000, chances are you're not going to qualify. Now the great thing about, it's $30,000 and $60,000. Now the great thing about the VA program as I'm standing here today is that currently there's no look back period. Meaning you can be over in assets today, then what we would do is set up what we call a Veterans Asset Protection Trust. Think of it kind of like a piggy bank. Move the assets into the trust. The family or the kids, someone other than veteran has to manage that money, so it could be a son or daughter. But once we've moved the assets into that piggy bank, the next month we can submit an application and get qualified. So you can have $100,000, $300,000, move it into the Veterans Asset Protection Trust, and then the next month you can get qualified. Now chances are there's going to be a look back period. Okay, they've already tried to pass it. Most likely it's going to pass near the end of the year, where they're going to look back 3 years to see if you moved any money around, similar to how Medicaid has a 5-year look back period. We haven't seen the final rule, so I can't tell you exactly how it's going to work, but I can tell you this: if you have an application and you submit it prior it's going to be grandfathered in. So we're rushing to make sure that veterans and surviving spouses who may qualify can get qualified before the end of the year, because at the end of the year there's probably going to be a 3-year look-back period. Okay? So that's the veterans benefit. It's a great way to pay for long-term care. A married veteran can receive up to $2,120 a month. A single veteran can receive up to $1,788. If we have a married couple where the veteran is healthy, but it's the spouse that needs care, we can bring in $1,404 a month tax-free. And then if we have a surviving spouse of a veteran, we can bring in $1,120 a month tax-free. Is there a question?
If they divorced that veteran.
Right. So the comment is, what happens if we have a surviving what happens if a surviving spouse gets divorced from a veteran? They're not a surviving spouse.
Yep.
Okay. Or husband and wife, veteran passes away, and then that surviving spouse remarries someone.
Yeah.
That also disqualifies her to receive any benefits. Okay. So it can be a little bit confusing there.
So for a surviving spouse of a veteran,
Right.
and if you have the military paperwork that we just
Sure.
discussed,
Yep.
then you would need a copy of a marriage certificate to prove that they were married?
Correct.
Okay.
Yep, yeah. So with the VA paperwork, there's a lot that needs to get submitted. They ask for a lot of information. But it's a great benefit, one of my favorite benefits, and it's a great way to help pay for long-term care. Next, we're going to talk about Medicaid. So Medicaid is the 6th way to pay for long-term care. So the VA helps pay for home care, assisted living, but when you get to paying $10,000, $11,000, $12,000 a month in long-term care, that $2,000 a month VA benefit is a drop in the bucket. So we look to Medicaid when we get to the nursing home. Medicaid can pay basically the entire cost of the nursing home care, but they're going to take your income. So that Social Security pension is going to be what's called a patient pay amount, leaving you at the end of the day, you're allowed to keep $60 a month worth of your income. So you can pay for basically a haircut each month. Now, if you're a veteran, you're able to keep $90 a month of your income, so you can get your haircut and your nails done, potentially. Medicaid has an asset limit. Single individual can only have up to $2,000 of countable assets. Married couple, where one spouse is in a nursing home, one spouse is living at home, can keep up to $119,000, but they make you cut your assets in half to qualify for that. Now, you might be saying, well, I can just give away my assets to qualify for Medicaid. Unfortunately, there's a look-back period. They look back 5 years to see if you moved any money around. And if you moved money around, they're going to penalize you. And they look at the amount that you've given away over the past 5 years, and they're going to penalize you based on that amount, saying that you can't qualify for Medicaid until you go a period of months based on how much you've given away. We call that the divestment penalty. So there's a lot of myths with regards to Medicaid that we hear out there. And the first myth is that if you're on Medicaid, you're in some rundown nursing home. And that's not the case. Who here's heard of Fox Run in Novi, right? They have a chandelier, movie theater, that type of thing, thought of very nice. Or Willows and Howell. These places do accept Medicaid. Now what they do is they play a little bit of a game of saying, oh, we don't have any Medicaid beds available. But if you can private pay for 1 month, 2 months, or 3 months, then magically a Medicaid bed's going to open up. So when we're doing this planning, a lot of it is all about having choices. So what if we set up an asset protection trust, moved our assets into this trust, where now if we can go 5 years, everything inside of that trust would be protected. We could private pay a couple months to get into that nicer nursing home and then switch over and qualify for Medicaid, where we're going to receive the same level of care as everyone else inside that nursing home. Because legally, if you're on Medicaid or private paying in the same facility, you have to receive the same level of care. So we could have Medicaid paying that base level of care, and then we could have a pot of resources available to pay for additional services, or if we're a married couple, to make sure that if one spouse needs long-term care, I'm not completely impoverishing the healthy spouse. Is there a question?
So you're suggesting then through this, the Veterans Asset Protection, that those monies, even though it's a moved
Sure.
monies, can be used to offset whatever their needs are.
Right. Yeah. So
to an irrevocable trust, which they have to sever all time.
right. So we'll talk about, the question is talking about a Veterans Asset Protection Trust. We'll talk more about trusts in a moment and talk about the different types of trusts. But the idea is that we can move the money into the trust, and that money could be used to pay for additional services or to improve quality of life, depending on how the trust is set up. Yeah. Question.
Okay, well, mom only has so much money.
Mm-hmm.
And if we did an asset trust, you would take some of that money and put it in an asset trust? Would Medicaid say, you know, hey, you got rid of
Right.
this money?
So the question is, by moving the money in trust, is Medicaid going to penalize you for
Yeah.
that? The idea is that we do this 5 years before we get to the point of needing nursing home care. So if we've done it 5 years ahead, they can only look back 5 years to see that you move money around. Right, yeah. So that's the idea, is that the closer to 5 years we get, more of the money's protected. Now I want you to also understand that there's a big myth that you have to wait 60 months to qualify for Medicaid. Understand that if you have a loved one in a nursing home now or near nursing home level care, we have what we call crisis planning strategies. So if you had a loved one in a nursing home now, I'd probably be able to protect through crisis planning strategies up to about 50, or at least 50% of the assets, okay? So you don't have to just engage in this nursing home or Medicaid spend down. If you have mom or dad who's in a nursing home now paying $10,000 a month, I can get them qualified for Medicaid and probably protect at least half of their assets right now. Versus planning ahead, if we can make it 5 years, we can move the money into the asset protection trust, and I know I can protect 100% of whatever is inside that trust. So understand, we have crisis planning strategies where we can protect generally at least half of the assets, or we can plan ahead and probably protect all of the assets for Medicaid purposes, okay? Another myth, they can take your home. So I talked about countable assets. Countable assets are basically everything except for personal property, your home, small cash value of life insurance, and an automobile. Everything else is countable. So the home is protected while you're alive, but they can take your home when you pass away. In 2011, Michigan passed what's called a state recovery, where they can now place a lien on your home when you pass away for whatever cost of care Medicaid paid out. So if you got $50,000 worth of benefits from Medicaid, they can place a $50,000 lien on your home when you pass away. The way it works right now is if that home ends up going through probate, they can place a lien on that home, okay? So the way we avoid this is with what's called a ladybird deed or a legacy deed, okay? So think of it kind of like a beneficiary designation for your home, where it's in your name during your lifetime, but if you pass away, it avoids probate and avoids estate recovery. Now that said, the ladybird deed works today, but it may not work in the future, because what's going to happen is they're going to pass enhanced estate recovery. They've already tried to do this once, and they're going to try to do it again, and many other states around us already have enhanced estate recovery. And the way enhanced estate recovery works is they don't place the lien when you pass away, they place a lien on the home when you enter the nursing home and qualify for Medicaid. So these ladybird deeds that all these attorneys are doing are going to end up blowing up when enhanced estate recovery comes along. The way we avoid this is, even though the home is an exempt asset while you're alive, we move it into that asset protection trust for a variety of reasons. First, to avoid estate recovery and avoid probate, but also what good is that home doing? A lot of times we want to sell that home to maybe pay for additional services. So if it's in the trust, we can sell the home and protect the proceeds of that sale. Or we could even downsize if we wanted to and still protect that home and protect those assets inside of the asset protection trust. Yeah, question?
So, as far as quick claim deeds, is that like no longer?
Right. Yeah, so the question is, what about a quick claim deed? So in the past, a lot of people would do what I call the deed in the drawer trick, where they do a quick claim deed, but they don't record it until someone passes away. There's a lot of issues with this. First of all, it creates confusion. Second of all, families have lost that quick claim deed and not been able to record it, and that house ends up going into probate. Third, when you sign that deed, technically it's a transfer, and you're supposed to notify the tax assessor of any transfers. You have to do what's called a property transfer affidavit. It's supposed to be submitted within 45 days of signing that document. Well, what happens when you sign a deed, 10 years go by, mom passes away, and now you record that deed that should have been when you should have notified the tax assessor 10 years ago of the transfer. They're not going to be too happy. So we don't do any of those. I'm not a big fan of the deed in the drawer trick. Instead, we'll either do the legacy deed or ladybird deed, or we'll deed the property to the asset protection trust, typically. Yeah. So they can take your home when you pass away. You have to give away your assets to protect them. You don't have to. We could set up an asset protection trust, and we'll talk more about that, where you could be the trustee of the assets. So you can be in charge of them. There's different types of irrevocable trusts.
The word "you" means the person in the nursing home, or the person overseeing the person?
The person we're planning for. For example, you could set up your own asset protection trust, and you could be trustee of it, or your dad could be trustee of his asset protection trust. Yep. Yeah. So again, I'm not a big fan of giving assets away. We shouldn't be giving assets to the kids. I want you to be in control as long as possible. Understand Medicaid's complex. It's tricky. There's a lot of moving parts, and it's important that we avoid all of the pitfalls that go along with it. Then next, we're going to talk about surprised or unanticipated beneficiaries. First, who's this? Judge Judy, right? So Judge Judy, she's still on TV. It's not Dancing with the Stars, Judge Judy. And what this tells me is people are still getting sued. And it might be because you get in a car accident, might be maybe you're a business owner, maybe you have a property up north, hunting accidents, things happen, maybe a divorce. So there's things we can do to protect you from this, protect you from the Judge Judy. A lot of times it's involved setting up an asset protection trust or protecting your beneficiaries as well. Now we're going to meet a couple people. So the first person we're going to meet is Elaine. And Elaine is your husband's next wife. In the months since your death, she's brought home-cooked meals to your husband 6 times. Each time she visits, she wears a skimpier outfit. She can't wait to redecorate your home, especially that hideous wallpaper that you chose. And she thinks there's no good reason that money earmarked for your children shouldn't be spent on more important things like jewelry, sports cars, and European spa vacations. So the question is, do you want Elaine to get your children's inheritance? Now you might be thinking, well, how would this work? Well, let's think about it for a second. We have husband and wife. What happens if wife passes away? Where does everything go? Husband, right? A married couple, right? Yeah. Okay, well then Elaine comes along, husband falls in love, they get married, title things jointly because that's what married couples do. What happens when husband passes away? Where do the assets go? To Elaine. Who doesn't get anything?
Kids.
The kids, right. And this happens all the time. And it's not just second marriages. We see this happen in first marriages. So what we can do is we can set up a trust that provides for that surviving spouse, but if that surviving spouse passes away, the assets don't go to Elaine, they go back to the kids. And it's all about having proper planning. Now we're going to meet someone else. This is your son-in-law, Fred. This is a picture of me when I was in college. Just kidding, just kidding. This is your son-in-law, Fred. Fred hasn't had a job since 1999, belongs to a religion you consider a cult, sells t-shirts at concerts by a band called Fish. You think he's fond of chemical substances, and he thinks it's great that he has rich in-laws. So the question is Fred going to get half of what you leave to your daughter, right? So we talked about this a little bit. And the issue here is what I call the pillowcase of money issue. So if you name your kids outright as beneficiaries, so let's say your daughter, 3 kids, you named her as beneficiary of your IRA, of your life insurance. What happens when you pass away? Everything goes to her, right? What happens if she then gets divorced from Fred? Fred gets half, right? What happens if she passes away? Fred gets it all, right? Versus maybe you want to protect her or make sure it goes down to the grandkids. So this is the pillowcase of money effect. And we're not protecting her from her own poor financial mismanagement. What we're trying to do is protect against the divorces, the lawsuits, the creditor actions, things that maybe it might be out of her control. So you might be thinking, well, I have a trust. My daughter's protected already. Well, what does your trust say? Most trusts that I review say outright distributions once the kid reaches age 25 or 30 or 35. And the issue with this is what I call the wall of time. All you're doing is launching a pillowcase of money over this wall of time without any knowledge of what's going on. So let's say your trust says outright distribution once my child reaches 35. Well, what happens when she gets divorced at 36? Where does that money go? To Fred. So instead of that pillowcase of money approach, what if we could build in lifetime asset protection for our children, where we could protect our children for their lifetime from the Freds of the world, from the Judge Judys of the world. So instead of that pillowcase of money, think of it, it could work more like a safety deposit box. And this would be a situation where you trust your daughter to make good decisions or your son to make good decisions, where you feel comfortable that he or she can manage the money. So think of it kind of like a safety deposit box. Okay? It's like when you walk into the bank. You can't just go in and take your money out of the safety deposit box. Instead, you walk into the bank, you turn a key, and someone else, the banker, turns the key, right? Then you can take the money out. Well, we're creating the same thing when we're building lifetime asset protection for our kids, where instead of saying it goes outright to your daughter, it goes to your daughter in trust. She can be the trustee of it. She can receive all the income. She can decide how the investments are invested. She can receive those required minimum distributions. And then if she wants to take the principal out or take the assets out and put it to do whatever she wants, she turns a key, and then at that time, she can pick someone else, could be a spouse, could be anyone she picks, to also turn the key. So that key holder can't go in and take any money out. Their only role is that of a key holder. And your daughter can pick and choose and change who that key holder is. So that's the way that we can build in lifetime asset protection, where she's in full control, but is protected against the divorces, lawsuits, creditors, bankruptcies. So we give her the opportunity to take all the money out if she wants to, but we're giving her the opportunity to leave it in trust so it's protected from the divorces, from the Freds of the world. Does that make sense? Yeah. And in most estate plans I review, it's, again, that pillowcase of money approach. Outright distributions at 25 or 30 or 35. Yep.
Sorry to interrupt you. So if I were to get a trust for my son and put my money in it and have somebody designated as the other key holder so that I can ensure that he won't make poor choices.
Sure.
And then I pass away.
Right.
Are you saying that he then can choose who he wants to be the other key holder, or does that have to remain as the key holder that I designated?
Right. So the question is, if I were to pass away, would my son be able to change the key holder? And the answer is,
It depends.
it depends. It depends on however you want to set it up. Okay? So there's a lot of different options, right? Yeah. So we can set it up however you want. Yeah. Question?
You have annual requirements then to file the trust return and pay taxes?
So the question is about taxes. The way we would set up the trust, we want to try to keep it so it's what we call a simple trust where all the income comes out of it. So you would have to pay taxes the way you normally would. So with our required minimum distributions, all of that would come out the way it normally would. So that would be the income coming directly to the child. We wouldn't have to pay compressed tax rates. Okay, we'd just pay personal income
But
tax.
they wouldn't be paid at the trust level?
No, wouldn't be paid at the trust level. Now we're going to meet someone else. This is your son, Marvin. He started 16 businesses, 4 retail stores, 6 multi-level marketing schemes, 3 franchises, 3 real estate deals, all have failed. He's asked you to financially back each one, asked you to bail him out of each one, has gone bankrupt twice, owes $120,000 in back taxes. So the question is, are you sure you want to leave your life's work to him, no strings attached? So in this situation, you wouldn't want to name Marvin as trustee of his own trust. You would want to appoint someone else as a trustee to manage that money. So those are the threats, the predators. Now we need to understand the options. Yep. So we need to understand the options. And what is life care planning? It breaks into 3 different things. Who's in control, who gets to benefit, and when. And so I want you to be in control as much as possible. So while you're alive and well, business as usual, you're in control. You become incapacitated, we're relying on your rule book, not the government's rule book. If you pass away, you're in control of where your stuff goes and who does it go to and how does it go to them. And then if we leave it to a spouse, we can protect against the Elaines of the world, and then we can decide how we're leaving things to the children. So the goals of a plan: stay in control, don't be a burden on loved ones, keep things simple, and know the difference between documents and planning, and understand all the costs and how to minimize those costs. So option 1, relying on the government's rule book. Okay? We don't want to do that. That's the guardianship, that's the probate, that's the estate administration. Option 2, creating your own rule book so that you're in control, protecting yourself from long-term care costs. So how do we do this? A lot of times we're doing it with a trust, and there's different types of trusts. We have revocable trusts and we have irrevocable trusts. So with a revocable trust, we can do a couple things. We can avoid probate and we can also control that distribution. But only if it's set up properly. Unfortunately, when I review a estate plan, a lot of times, even though they have a trust, they're not going to avoid probate because they don't have their trust funded properly. We take funding very seriously at our office. Controlling that distribution. A lot of times when we review a trust, it says outright distributions at 25, 30, 35. We're missing the opportunity to protect our kids from the outside environment. But a revocable trust, if it's set up properly, funded, can do these 2 things, and it does a great job at that. Now let's talk about an irrevocable trust. Irrevocable trust can do that, avoid probate, control the distribution, protect the kids, but also it can protect you. Protect you against long-term care costs, protect you against lawsuits. And we talked about how that works, how we can start that 5-year look-back period for Medicaid purposes. We can build in that immediate protection against lawsuits. Now let's compare the 2 types of trusts, because these aren't the irrevocable trusts of old that we used to use when we were planning for estate tax purposes. So typically the trust we use in our office, we call it an asset protection trust. Okay? So let's compare the revocable trust to the asset protection trust. With a revocable trust, you receive the income from the trust. It's not taxed at a trust tax rate. With our asset protection trust, you receive the income from the trust. It's not taxed at a trust tax rate. With a revocable trust, you can serve as trustee and you can change who the successor trustees are at any time. With our asset protection trust, you can serve as trustee, you can be in charge, you can decide how the assets are invested, you can buy a house, you can sell a house, you can go from Apple stock to Google stock. And even though the trust is an irrevocable trust, you can change the trustees at any time. You can change the successor trustees at any time.
So the asset protection does fall within the irrevocable.
Right. Yeah. So I don't want that word irrevocable to scare you. It can mean a lot of different things. But with our irrevocable trust, our asset protection trust, you can change the trustees at any time. With our revocable trust, you can change the beneficiaries at any time. With our asset protection trust, you can also change the beneficiaries at any time. So I threaten my kids that if they don't eat their broccoli, I'm taking them out of the trust. It doesn't work as a parenting technique, but it's perfectly legal. With a revocable trust, you can take the assets out of the trust at any time. You can empty the trust. With the asset protection trust, you can take the assets out of the trust at any time. However, you need one other person. So it's like that safety deposit box concept. The key. So if you're a married couple, you have one key, and then you can give the other key to the kids. Now the kids can't go in and take your money out. Their only role is if you call them up because you're going to take $20,000 out of the trust, put it in your name to go on a cruise around the world. So you call up little Johnny and say, hey Johnny, we're going on a cruise. We're taking $20,000 out of the trust. Is that okay? What's little Johnny going to say?
Have a good time.
Have a good time. He's going to say yes, right? But what if little Johnny says no?
It depends.
It depends, right? So if little Johnny says no, guess what? He's not a key holder anymore. He's not a trustee, and he's removed as a beneficiary. So he's cut out of everything.
Do you have to go through the court process in order to...
So the question is, do you have to go through the court to do this? No, you don't, because the trust allows you to make these changes. Okay? Even though the trust is an irrevocable trust, we build in flexibility to make these changes. So does a revocable trust protect against long-term care costs or lawsuits? No. Does your asset protection trust? Yes. So a lot of times we are looking at a trust as a way to try to protect our stuff. Okay? So we need to make a distinction between good marketing and good lawyering. So you might have, and we talked about this a little bit already, there's one thing to have a trust or a will, but what does it actually say? Versus what we try to do is we try to personalize it to your situation. Okay? You asked some questions I had to answer with it depends, because it depends on what your goals are. What are you trying to accomplish? Right? If I asked you to bring me a paintbrush, what type of paintbrush are you going to bring me? So do we want personalized rules like that personal care plan? Do we want the asset protection? Do we want a plan for the IRA? Do we want to protect against the Elaines of the world? Do we want to protect against the Freds of the world? We do that by putting that into the documents. It's not just enough to have a trust, but what is this trust actually accomplishing for you? Yeah.
My mom watches Susie Orman all the time, and I have to hear it. But
sorry to hear that.
she's been after me. I want an irrevocable trust. I want an irrevocable. She has no assets.
Right.
She's got 20 grand in the bank, and when that's gone, she's Medicaid.
Right. Yeah.
So
yeah.
I don't think she needs an irrevocable.
Yeah. So the comment is, mom's watching Susie Orman, hearing all these things, say, I need this, I need that. Does she need a trust? The answer is, it depends. But a trust isn't for everybody. And that's the point is our process, we figure out what exactly your goals are, and then we give you different options based on that. Does everyone need a trust? No. I've had clients that had $3.2 million, and they had a will-based estate plan where they're just relying on beneficiary designations to take care of everything. But I've had people that have $50,000 in a home, and they have an asset protection trust because they want to protect everything. So it's all about what's important to you, what do you value, and then based on that, we come up with a plan that makes the most sense. So it's one thing to have that rule book. It's another thing to make sure it's financially integrated, because a trust by itself, it's just an empty suitcase. We need to actually put assets into the suitcase, make sure that the trust is funded properly if we do have a trust, or make sure that we have beneficiary designations set up properly. So think of a trust or a legal plan similar to a car chassis. We need to make sure that we drop the engine in there, and that's the financial piece, where all of these pieces need to fit together. So the question is, once I have this rule book, I have my estate plan, am I all set? And the answer is, it depends, right? Because things change. Your family situation changes, finances changes, health changes, laws change, different strategies come about. For example, without even looking at your estate plan, if it's older than 2012, I know it's missing key language with regards to your power of attorney. Things are constantly changing. So it's important to make sure it's maintained, it's updated. And we give our clients 2 options on how to maintain their plan. Option 1 is you maintain it yourself. So you give me a call whenever you want to come in, and there'll be a fee associated with that and a fee for whatever work. But the ball is in your court. The responsibility is in your hand, in your shoes, to raise your hand and say, hey, Chris, we want to come in and talk. That's well and good, but we also offer our clients another opportunity, and that's called the Client Care Program, where we meet on an annual basis, review your plan for changes in law, changes in family situation, and go ahead and update your documents at no additional cost, though we charge $475 a year for that Client Care Program. Okay, so we give our clients an option. So as we're wrapping up the goals of the workshop, identify if your current plan meets your goals, figure out if you're all set, understand what it takes to protect you or protect a loved one against the threats, and then show you how to get what's missing. So we started with a slide of common questions. Is there any other questions where you're thinking, gosh, I wish Chris would talk about this or answer this question? Yeah.
I just have a question. I don't have any children.
Mm-hmm.
I'm not married.
Mm-hmm.
So I have beneficiaries like my brother or my sister or whatever.
Mm-hmm.
I do have a condo. I don't have a will. I don't have anything.
Mm-hmm.
If I don't have anything and my condo goes to probate,
mm-hmm.
or my 457, I think would still go
mm-hmm.
to a sibling.
Mm-hmm.
So they wouldn't have, would they get penalized in any way if the state just came and took my condo?
So the question is, I'm relying on beneficiary designations and whatnot. The condo would probably go through probate.
Yeah,
right.
I would say take it. It's
Yeah.
underwater.
Yeah. And for you, if you don't have children, you're not married, the important piece isn't necessarily planning for what happens if you pass away, but planning for what happens if you don't.
Yeah.
And getting the powers of attorney in place. Who's going to make decisions for you during your lifetime?
Yeah.
A lot of times with clients in that situation, they're more concerned about that
Okay.
Versus where my stuff goes after I pass away. Because, hey, sometimes the best estate plan is go when your last check bounces, right?
Yeah.
Yeah. Yeah.
Yeah.
Was there another question? Yeah.
So going back to the getting married again.
Sure.
Second marriage.
Right.
Whatever. If 2 people were to get married, but they kept their finances separately.
Sure.
And in their own names.
Sure.
As such, and had already maybe designated their children.
Sure.
As
Right.
POD, then is there still a problem if those 2 people were to get divorced?
Sure.
again, and
Yeah.
do they get half?
So the question is, if second marriage and you keep everything separate, and then you get a divorce, are the assets protected? And the answer is, it depends. And it's going to depend on how good your divorce attorney is. Okay? Versus setting it up inside of a trust, you're 100% protected. Yeah. Yeah. So great questions. Yeah. One last one.
My question is, if we schedule an appointment with you for a particular need,
Yep.
say VA
So we'll
benefits, but we might
yep.
need other things.
Yep.
How long is that process? Is it
Yeah.
6
So how long
months
is the
or
process?
less,
Yeah.
or-
Yep. So the answer is it depends on what we're doing, unfortunately. So the next step, and we'll talk about the next step in the process, is how we can figure out that answer for you. Okay. So we'll talk about that in a second. Yep.
You know, you spoke about you weren't a fan of
Joint ownership.
accounts.
Correct.
Joint
Yep.
Whatever. Let's say, and I understand based on like I have a 20-whatever-year-old son.
Sure.
Who's got a house
Yep.
and money. I am on his account.
Mhm.
So you're saying if something happens to him, because I'm on his account, they can sue my account as well?
No,
Even
so,
though he's
yeah,
not on
so
my
the-
account, he's a beneficiary.
So the issue is with joint ownership, if you're joint ownership with a son and you're joint on his account and something happens to him, he's going to lose just the things that he's tied to. So if he's not tied to your accounts, your accounts are protected. Yeah,
But
great question.
then my next question would be,
Mhm.
and I need a clarification first. So, God forbid, if I put me as a beneficiary instead of a joint account, and he ended up in a hospital setting.
Right.
How do you get that money? You have to go to court.
Right.
But if you're on the account, then you just go get the money for his needs. So there's
Right. So
tons
again, the issue is with
of both, not
joint ownership, but you can do that through either powers of attorney or transfer on death versus joint ownership.
Yeah,
So
but God
yeah,
forbid, he's
right.
not dead. Maybe he's in
Right.
you know what I mean?
Right, and that's where power of attorney is.
His son- your
Right,
son
power of
can
attorney is
get
going
the
to
power
take
of
care of that.
attorney.
Yeah. So
Now-
great questions. So
Okay.
we started with promises, 3 promises. Time fly by.
Yes.
Yeah. Did we learn something new?
Yeah.
Do we have a little bit of fun? Meet some crazy characters like Elaine and Fred. Right. Then if you could take out the evaluation, I'd ask that you keep your promise. Remember, the rating scale is 5 being excellent, 1 being poor. If you circle all ones, they're going to assume you screwed up. You meant to say we're excellent. And then if you look at the bottom of the workshop, or of the evaluation, you have a chance to sit down for what's called a vision meeting. So this workshop has been all about what goes on in our office, learning about the rules, learning about the environment, and learning about how we can protect ourselves. That's all well and good, that's information, but the most important thing is that we need to act on this information. And so the next step in our process is what we call a vision meeting, where we sit down and figure out what's going on in your world, figure out if you're really all set. So we look to see where you're at, and we figure out where you want to go, and then we figure out if there's a gap. And if there's a gap, then we're going to talk about different options and how we can close that gap. And that's in our vision meeting, and that's the next step in our process. So typically we charge $450 for the vision meeting, but because you listen to me blabber on about death, taxes, and incapacity, you're not going to ask me any criminal law questions. We're going to waive that fee for that vision meeting, so there's no cost to that vision meeting if you want to set it up. And if you do want to set that up, then just mark yes on the evaluation, and then our office will give you a call probably tomorrow or next week to set up that vision meeting. Now typically we like to have these vision meetings within a couple of weeks of the workshop so that the information is still fresh in your mind. You might be thinking, well, this is great, you know what, I'll just give you a call in a couple months to come in. Unfortunately, we would have to charge for that, because what's going to happen as soon as you walk out this door is you're going to forget half of what we talked about, and then if a month or so goes by, you're going to forget the other half. So if you do want that vision meeting at no cost, make sure to mark yes on the evaluation, and then our office will give you a call within the next day or so to schedule that at one of our locations, and this might be the easiest location for you.
And that would just be, the vision meeting would be just to see what we should do,
right.
Should do
Yeah.
for us.
Yeah, so the vision meeting, what's going to happen is, and we can either be planning for you, or we can be planning for a loved one, or we can be planning for both. What we're going to do is either myself or Brandon, another attorney, we're going to sit down and figure out what's going on in your world. And we're going to figure out where you're at. And we use a tool we call a estate planning audit, where we look through the plan, and we have 15 points we go through together. So we figure out where you're at, and then we're going to use a tool called a vision clarifier to figure out where you want to go. And generally there'll be a couple different options on how to get there, and then at the end of the vision meeting, based on those options, we'll quote you a fee or investment to get that done. Okay, and typically, I know you're asking how much is it going to cost. The answer is,
It depends.
it depends.
On what you need.
Right, it depends on what you need. Typically, you're looking somewhere from $1,500 to $10 grand on the high end. Okay, if we're talking about crisis situation, then it could be a little more. But at the end of the vision meeting, based on where you want to go, we'll have a set fee for you. Okay, yeah.
And what kind of information or paperwork would you need from us
Sure.
for that?
Yep. So the question is, what information do we need at the vision meeting? What's going to happen is we'll send out a short questionnaire, about 6 pages, that provides a good foundation for that vision meeting. And then if you do have any plan already in place, bring that plan. If you don't have a plan, then don't worry about it. But the most important thing is that personal information form, because that'll provide us a good foundation for that meeting.
I have one other question.
Yes.
My brother went and paid $400 for 1 hour to talk to
Sure.
a planner or
Yep.
whatever, and I just forgot where I'm going.
All right.
Okay.
All right. So with that, I want to thank everyone for taking time out of their day to listen to me blabber on about death, taxes, incapacity. If you could just fill out that evaluation. If you do want that vision meeting, mark yes. And then if there's anyone else, any other family members or colleagues or coworkers that you think would benefit from attending one of our workshops, just put their information at the bottom, and we'll send them an invitation to one of our upcoming workshops. So with that, I thank everyone. Thank you.
Thank you, Chris.